6/2/2017.
12. Yes, my lord.
Okay.
I allow one matter. Another hearing. 7.
My lord, this matter has been
Call the list.
But in this case, they are mentioned for correction of some typographical mistake. Now, can you see page 7 of the judgment?
Yes.
From top, my lord, second paragraph, second line. Well, third line. The insurance company is liable to pay 60% of the sale. So the 50%, instead of 50%, it will be 60%. Page 7.
Okay.
And another, my lord, kindly see from bottom, my lord,
No, the calculation part is correct.
calculation part is correct. Only, my 30.
So the 60% is 30 lakh.
Yes, yes.
49,200.
But calculation part is correct.
Okay.
And
It
another,
will be
my lord,
60% instead of 50%.
yes.
And
Another, my lord, in the middle portion, your losses kindly see 30,41,200 has been written instead of 30,49,200. Only through this, my lord, typographical mistake. Here, my lord, kindly see
yes.
middle portion of
Got
the
it,
same
got
page.
it, got it, got it.
Yes. Other
This-
part is same.
Okay. This matter appears for correction or the learned advocates. It appears that in page 7 of the impugned judgment dated 22nd of September 2023, there are some typographical errors. Accordingly, the typographical errors are hereby corrected as follows. Stop. In next paragraph. In second line of paragraph of second paragraph of page number 7, the 50% would be read as 60%, and in the 14th line of the same paragraph, the amount should be read as 30,49,200 instead of 30,41,200. The remaining portion of the judgment would be remain as same. Let this order be made a part of the judgment dated 22nd of September 2023.
Your item 5, it was yesterday's matter.
Yes.
Not Mr. Maiti again, will not a few minutes back will not request him to be with a short pass.
Very well.
Let him come, Milord. If he comes, will not wait. I'm grateful to your option.
Next.
Lordship, in item number 8, I am for the respondent, Lordship. I pray for short pass over, Lordship. If the clients are present, Lordship, there was personally appeared, they are personally appeared, so, Lordship, so I am praying for a short pass over, Lordship. My senior will come.
No, who is for the appellant? You are for the appellant.
Yes, my lord, I am praying for not today, my lord, on monthly.
পার্সোনাল অ্যাড্রেস আছে ওরা এসেছে আজকে সেটা তো করে নিতে হবে না সেটা কর
My lord, I am interpreting, my lord. There was a direction for personal appearance of the injured person along with his wife. Because the check was issued in favor of the injured, not in the injured person, but of the wife of the injured person. That is why your lordship directed.
The injured person, the wife represented the husband, and there was no representation letter, nothing
In the LCR.
observed by the learned tribunal. That's why my lord has
Both the wife and the injured person is present.
Yes, who is appearing on behalf of the respondent?
Ranjit Mukherjee. Another.
What is the merit of the appeal? You have preferred the appeal.
no, I have.
One affidavit is already prepared, and that is required to be affirmed. But due to seriously injured, but till today, he is not in a position to move. That is why.
Very well. Only the query is whether the injured person has authorized his
Yes.
wife to
Authorize.
move this matter.
But that is not in the record. Yes.
Yes. Where is
Yes.
the record?
That is the lacuna of the lower court lawyer. হ্যাঁ মানে দিয়েছিল ওরা ওরা দিয়েছে ও তো এখন তো হাজির আছে ওয়াই
No authorization is there.
injured person is present. Kindly ask.
No, this is not the procedure, you know. This is not the procedure, you know.
Not observed by the tribunal.
You file one affidavit or any authorization before this court, that can be considered.
Yes. Affidavit is being found. That is ready. Ready আছে তো affidavit?
File this.
File
My senior will come, lordship. I am doing
No,
the
where is the
pass-
authorization? Where is the requirement of senior?
Big pass. Lordship, kindly pass on the letter.
Very well.
Short pass.
I don't want to put them hold in this court, you know. So why they shall stay here? You file the authorization, that is sufficient, nothing. They appear and file the authorization, that is sufficient.
yes. Your person is present, he will submit a
Yes,
authorization.
that is sufficient.
That
Nothing more is required here.
affidavit. In course of this day, he will submit. Kindly short pass over at 12 p.m. Kindly you also kindly take up this matter.
You file one authorization, serve a copy to the appellant.
Yes.
Okay.
They are present. I will no, এটা তোমাকে দিয়ে দেবো।
অ্যাফিডেভিটটা আগে ফাইল করে নিয়ে তারপরে আমাকে সার্চ করে তারপরে আজকে কোর্টে আসা উচিত।
কিন্তু ওকে তো 3 দিন আসা সম্ভব
Very well, pass it over.
Yes, 3 দিন আসা সম্ভব নয় ওকে একদম মুভ করতে পারে না এখনো পর্যন্ত আজ আর এবারে 7-8 বছর হয়ে গেল এখন মুভ করতে পারে না।
Did নাকি আমাদের?
No, what, you, in which matter?
5.
Call the 6.
So at number 6, lordship, collect that. I have placed that I have prepared an appeal. It is the lordship order of dismissal. The learned tribunal don't find the detailed number in the copy of the policy. And lordship, the lordship was pleased to direct the insurance company to place that the policy This is total. And lordship, my narration also complied the lordship's order.
Yes.
And lordship, to that extent, lordship, I have filed one application for additional evidence. Lordship, prior to that, lordship, kindly pass the judgment, so lordship can memorize the entire. So lordship, kindly come to the paper book, page 29.
Yes.
Last paragraph before order. Page 29, just before order, lordship. Upon hearing the learned advocate both sides, considering the materials and evidence on record, we find that one, Najmul Sheikh died in road traffic accident caused by offending truck, but here I find that the petitioner has failed to produce any document to show that at the time of accident, offending truck was insured with the valid insurance policy. The Xerox copy of the insurance policy which was submitted by the petitioner does not bear the number of the offending vehicle. So accordingly, case will be dismissed.
Yes.
So, see, my humble submission is that is the vehicle was the new vehicle. If the new vehicle, then the number will not appear in the policy. Subsequently, as and when we will get the policy, then number will come. Because after compliance, the registration authority will issue the registration number. Now, you kindly turn to page 14, like the charge sheet. Yes, charge sheet. Page 14.
Yes.
Plus, you kindly read the property description. Item number 3. RC book. Plus, you got it. RC book of JH05B 2051 in the name of Mohan Prasad, valid up to 6 February 2010. Then, Lordship, kindly. So, Mohan Prasad is the owner of the offending vehicle. Then, Lordship, kindly to my application, can 2. Page 7. That is the registration certificate. See here.
Can.
Can 2. Can
Yes.
2. Yes, Lordship, kindly turn to page 7.
Certificate of registration.
Certificate of registration. Lordship, kindly see right hand side 6 February 2010. Right hand side. And Lordship, kindly see the name Mohan Prasad.
Yes.
So, and Lordship, then Lordship, kindly come to the next page of the page 8 and type copy, Lordship, kindly to type page 8. And then Lordship, kindly see there I have annexed a copy of the policy. The copy of the policy issued in respect by endorse the engine number and chassis number. Then Lordship, kindly turn to page policy.
I've already given that.
Yes, Lordship, 20.
Certified to be true copy of all.
The original policy I have annexed. Lordship, kindly paperbook page 21. That policy also submitted by my learned friend, personal Lordship order. Lordship will find in the middle engine number. Lordship, kindly see the engine number 70M62.
Yes.
And Lordship, kindly see that that the registration certificate. Lordship will find that engine number. And Lordship, then Lordship will find the chassis number. The chassis number also same 426031. Last number 715.
Yes.
So the vehicle was insured, and this is the his intent to get the compensation. So observation of the learned tribunal on that score, I should not say bad, but otherwise not. I am not fails to convince the learned tribunal accordingly for order passed against me. That is I can say.
So why you file the can two?
Can to file lawsuit just with tally because of here lawsuit will find the registration certificate. The registration certificate not in the file
You file the registration certificate of registration
of the
and permit.
and permit. And permit where from lawsuit also find the inter.
Yes. Engine number, chassis number, everything.
Everything lawsuit will find. The even number, name of the owner.
So what is the matter about?
Matter about lawsuit on that score the claim application dismissed.
No, what is the merit?
Merit lawsuit with 163A. 163A.
163A.
So lawsuit I cannot go beyond that periphery of 3,000 per month. So can be assessed with that score.
Yes.
And 32 years, so 17 multiplier, 1/3 is be deducted. Here lawsuit the 163A, so should not 1/3 deducted, not half. So of that score,
Who are the claimants?
was the mother is the claimant.
Only mother.
Only mother is the claimant.
Very well. Please take down.
Only my lord, my formal objection.
The instant appeal has been preferred against the judgment and order of dismissal passed on 16th of September 2013 by learned judge Motor Accident Claim Tribunal at Asansol in MSC case number 65 of 2010. The brief fact of the case is that the present appellant, being the claimant,
সেখানে আবার দিয়ে দিয়েছি আবার সার্টিফাইড বলতে সেখানে আমি নিতে পারছি
has filed one application under section 163 of a Act before the learned tribunal for getting compensation on the ground that his son was died in a road traffic accident due to the involvement of the offending vehicle duly insured under the policy of the insurance company. Stop. The the insurance company contested the matter before the learned tribunal. Stop. After hearing the parties, the learned tribunal has dismissed the claim case on the ground that there are no documents before the tribunal to hold that the offending vehicle was duly insured under the policy of the insurance company at the time of the accident. The claimant has preferred this appeal before this court along with an application of Can 2 of 2023. By filing the Can 2, the appellant wanted to introduce some additional evidence according to the provisions of Order 41 Rule 27 CPC. It is the submission of the learned advocate for the appellant that those documents could not be produced before the learned tribunal. Accordingly, the learned tribunal has passed the erroneous order. Heard the learned advocate peruse the Can 2. It appears that the Can 2 annexed the certificate of registration and route permit of the offending vehicle. Stop. Next paragraph. During the course of hearing, one report is called from the respondent Oriental Insurance Company Limited to the fact whether the offending vehicle was insured under the policy of the insurance company at the time of alleged accident. One report was submitted by the learned advocate for the appellant containing inter alia that the offending vehicle was a new vehicle and before the registration of the same, the policy was entered into with the insurance company and the chassis number and the engine number of the said vehicle is tallied with the insurance policy. or the learned advocate peruse the report submitted by the divisional manager, Jamshedpur, considering the entire circumstances, it appears to me that the offending vehicle was well covered under the insurance, under the policy of the insurance company at the time of the alleged accident. Stop. On that score, the observation of the learned tribunal appears to me erroneous, and it needs to be set aside. It needs to be set aside. Stop. To consider just and proper compensation of this case, it appears to me that the application was filed under section 163 of MV Act, stating the monthly income of the deceased to be 3,300. Considering the facts and circumstances of this case, the monthly income of the deceased should be calculated rupees 3,000 per month. Stop. So the just and proper compensation is hereby assessed as follows: monthly income 3,000, yearly income comes to be 36,000. 1/3 is deducted towards his personal expenses. So after deduction, the yearly dependency comes to rupees 24,000. The applicable multiplier according to the age of the deceased within bracket 32 years is 17. Stop. After applying the multiplier, the award comes to rupees 4,08,000. Stop. The claimant is also entitled to get the general damages of rupees 9,500.
No, sorry.
It would be not 9,500. It is a mother.
It's 4,500.
It will be 4,500. Only mother.
Yes, sir. Only 4,500.
Okay. After adding all the head, the award comes to rupees 4,12,500. Stop. Next one. The insurance company is directed to pay the compensation along with 6% interest per annum from the date of filing of the claim application, that is from 2nd of January 2009. 2nd of January 2009. Stop. The insurance company is further directed to with the High Court.
Yes, sir.
Directed to pay the compensation through the office of the Learned Registrar and High Court, Calcutta. Stop. On such deposit, the claimant is at liberty. Only single claimant is at liberty to receive the same according to prevailing rules. Accordingly, instant FMA along with the CAN 2 of 2023 and other CAN, if pending, are disposed of.
Now, the insurance can be deposited by 4 weeks. 6 weeks.
6 weeks.
6.
That to pay.
I'm great.
Ten.
Nineteen, 21 and 22, 25, 28, 29, 31, 32 and 33, 34, 35, 36,
Your Lordship, for the petition at 37. Your Lordship, due to the death of our clerk, our file has been
Which
misplaced.
item?
37, Your Lordship.
37. You are for the
Petition,
appellant.
appellant, Your Lordship.
This is of Union of India. Yes, what is your submission?
Your Lordship, due to the death of our clerk, our file has been misplaced. During the vacation, we have turned our chamber upside down, but we still could not ascertain where the file is. Your Lordship, I'm asking for a liberty so that we can get the paper book xerox from the court's record at our own cost.
Who is appearing for the Union of India? Do you know?
No, Your Lordship.
Give me the papers. Paper book আছে? Sir, আছে। একটা দিয়ে দেওয়া যায়। কিন্তু হুইচ ফর দ্য মানে অ্যাপিয়ারেন্সের পক্ষে কি হচ্ছে অ্যাডভোকেট সে Yes. Who is for the advocate on record? Are you?
I'm not the advocate on record, Your Lordship.
Then-
Advocate on record was Mr. Pradeep Roy is leading me in this matter. Advocate on record was
Advocate on record Devashish Kormukar.
he's probably Mr. Pradeep Roy's previous junior.
So I can only hand over the paper book to the advocate on record. 8 paper books are there.
Your Lordship, we shall contact Mr. Advocate
Very
on
well.
record.
I am passing the order. You take on the next week. Okay. Learned advocate. What is your name?
Tirthojit Roy Chaudhary.
Tirthojit Das. Appearing on behalf of the appellant submits that the brief was misplaced due to the untimely death of the law clerk. Accordingly, he seeks some accommodation so that the appeal can be heard. After appeal can be heard after allowing him to receive a paper book from the record of the court. Stop. Considering the submission of the learned advocate, the appellant is at liberty to receive the paper book from the court. And the advocate on record of the appellant is at liberty. Last night to give a sentence to us. Considering the learned advocate, no. Considering the learned advocate on record advocate, the appellant বলেছে, comma the advocate on record for the appellant is at liberty to receive the paper book from the court. Let the matter appear in the list 7th of December. You receive in the meantime.
Lordship, I am for the appellant and led by Mr. Suman Chattopadhyay.
Yes. Which
Lordship,
for the respondent?
Appellate,
You are for the appellant.
appellate.
Eastern Railway.
Yes, Lordship.
Who is for the respondent claimant? Ajmira Miraj. Paper book filed.
Lordship, today I want to file the paper. I'm submitting the paper books.
Office. কত কটা ছিল অর্ডার দেখো হ্যাঁ yes
Paper book has
paper books are ready.
Yes.
paper book be filed and the साथ एक copy and Malam kindly fix the.
Okay.
His senior is call me.
Very well. Hand over the paper book.
এটা আপনি এখানে দুটো সাবমিট করতে বলে যাবেন দিদি আপনাকে দিচ্ছি আমি copy।
You serve one copy to the respondent.
স্যার
একটাই stop.
একটা দিলেই হয়ে যাবে কি না দুটো দিব
একটা ডিপার্টমেন্টে
হ্যাঁ
থাকে
হ্যাঁ
একটা ওদের
Please take down. The appellant had submitted paper books with the court after serving a copy of the same to the learned advocate to the respondent. Stop. The matter is otherwise ready for hearing. Please the matter for hearing on when next week?
Lordship, kindly not 10th. My senior has instructed me not to in 10th.
Not before?
Not in 10th. On 10th December, he's
Okay.
not available.
No, 10th December is the Sunday.
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 হ্যাঁ
আমাকে বললে 10 তারিখে মামলা আছে কেটে তো 10 তারিখ রিপোর্ট
Very well.
September is Monday.
I am fixing on 5th.
5th. Okay. Grateful.
Get money.
Grateful. Lordship.
Number 39. 42 and 43. 44. 45.
45 plus 5 for the
Yes, which for the respondent?
Mr. Konopyon Bandyopadhyay appearing for the respondent insurance company lordship.
Kanak Kiran Bandyopadhyay,
Yes, lordship.
National Insurance Company.
Yes, lordship.
Where is Mr. Bandyopadhyay? Now, what about
Lordship, I
tomorrow?
am not blaming to him, but he is not very regular. So, Lordship, kindly do one thing, Lordship. I have filed the paper book. Lordship, pass the direction, the paper book filed, and Lordship, kindly direct me to sub notice. The matter will fix on Monday. So, today I will take the notice.
Tomorrow?
Tomorrow, perhaps today is not available. Tomorrow, when is not available.
No, tomorrow you are doing the work or not? Tomorrow, Saturday, opening day.
Lordship, if Lordship asks
okay.
for his food, then I cannot answer properly.
Okay, I understand. Please take down. The appellant is present. Learned advocate for the appellant submitted paper book. Stop. Next, the learned advocate on behalf of the insurance company is absent on call. The matter is otherwise ready for hearing. Considering the situation, the learned advocate for the appellant is directed to serve notice upon the appellant, learned advocate for the appellant, informing the fact that the matter shall appear in the list on 20th of November.
20th. No, 20th. Prior to that,
No, 20th is Monday.
20th is the Monday.
20th,
Then let's see Wednesday.
22nd. 21 is the holiday.
21.
22nd. এই ভদ্রলোক কত নম্বর? Number 8. 5 থেকে ডাকুন।
Lord, kindly give me a short passover.
Yes,
Kindly give me a short passover. My senior is coming.
again Passover.
Just a
This
short.
is the second time. Give me the papers. What is the matter about? What is the application?
I don't. Lord, my senior is coming. The papers are with me.
Give me the papers. Have you served the application? What is the affidavit of service?
Sorry, I don't know what this-
Nothing is there.
Lord, he's on his way. He's just stuck in the jam.
Very well. Pass. রাখুন এটা। নাহলে কালকে ডেট দিয়ে দিন। Next.
Kindly consider the order passed by your lordship in last occasion.
No, where is the authorization?
First authorization is ready. I'm just giving. Lordship, first of all, the Raj Chandra Roy and Soma Roy. Lordship, Soma Roy is the respondent here. Soma Roy is present. And Lordship, the Raj Chandra Roy, Lordship, the husband who is the victim who suffered permanent disability, Lordship, he is also present. Lordship, authorization and an affidavit permitting Lordship, the wife of the Lordship, the victim to carry on all these proceedings, Lordship, both the affidavit and Lordship, I am submitting most of it. Lordship, it has been getting affirmed.
So you affirm the affidavit and file it.
Also, kindly, this is
I am
already.
recording the presence of them. Okay, I am
Lordship,
recording
they
their
are
presence.
the present. Lordship, both
I
are
am
present.
recording their presence only. Okay. The respondent, namely Shoma Rai, along with her husband, namely
Raj Chandra.
Raj Chandra Rai, comma, who is the injured person of this case, are personally present. Their presence before this court is recorded and their further presence is dispensary. Learned advocate for the respondent submits that in the course of the day, he shall file the required authorization and affidavit. Stop. Let the affidavit be filed during the course of the day. Release the matter for further hearing on December.
Or also already this hearing also already.
Who is for the appellant?
Uh,
Now tomorrow I do not know whether you are ready to do the work or not.
Also then, who is there?
Tuesday is the holiday.
Then next week any day.
Release the matter on Wednesday, 22nd.
Also further presence of this client.
Is dispensed with.
Yes.
Happy to answer. At 2 p.m. Yes, Mr. Anything is there?
I think the court will come back, Lord, if the other side comes in, Lord, if you are asking for.
Item number 5 I have called.
Lord, he was not there. He got the function is coming. Lord, in case he comes in, Lord, then shall we be
No, item
allowed?
number 5.
Item 5.
Item number 5 is one application is there for condonation of duty.
Lord, sir.
The appellant was directed to serve upon you regarding the condonation.
Lord, sir.
This is the matter. Only application is fixed today.
Lord, this
It can be disposed of today, no issue.
Yes, my Lord. Lord, that is why I was saying, Lord, if the other side comes in, my Lord, are we, my Lord, Lordship, must liberty to, my Lord, intimate to my Lord's officer that matter can be disposed of. Your Lordship will
Come at 2 p.m.
come at
No issue.
Lordship will once sit at 2 o'clock.
At 2 o'clock.
Lordship. Grateful.
Columnist. Yes.
Sir, I number 3 and 4.
We have concluded our part. We respond. True. Season's greetings, my lord.
Yes.
Shubho Vijaya,
Thank
Shubho
you.
Deepavali, everything together.
Same to you.
Deeply blessed.
जी तो आपको the first part. They will say.
To kindly take up 3330, Sierra 3330 of 2018.
Yes. Got it.
My lord's pleasure would be to kindly come to certified copy petition of complaint.
Yes.
Yes, sir. Now, there are a list of accused persons who are there as directors, and my lord's pleasure would be to kindly come to from internal page 5. May I just please for the cases so far as I am concerned? It's been a while, my lord, that we've argued this case, so I will just repeat the facts.
Yes.
Internal page 5. Your Lordship has got the internal page 5. My lord, this is a 156.3 application, first of all. It's not a section 200. Section 200 I'll deal with the same later. There are two cases. Now, today I will just be placing the company. Your Lordship would kindly permit me to place the company. Well, page 5, paragraph number 2, that the accused number 1 is a company incorporated under so and so, so and so, so and so, and the corporate office at the address given in the first line. The company is in the business of running resort and offering various holiday packages. Number 3, the accused number 4, 5, 6, 7, 9, 10, 11, 12, 13, and 14 are directors and office bearers of the company. The accused number 3 is the chairman of the company. The accused number 8 is the managing director, whereas the accused ভীষণ গরম হচ্ছে দাদা একটু চালিয়ে দিন ভীষণ গরম হচ্ছে তা তোমরা এই দিকটা চলে যাও হ্যাঁ 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 একদম মানে জিরো সার্কুলেশন আই এম সরি মানে
Yes, yes.
there is zero circulation. Division Detail Manager to the accused number 2 to 15. The accused number 2 to 15 are altered to the accused company sitting at its helm of affairs. The accused number 2 to 15 are also responsible for taking the policy decisions that determine how the business of the accused number 1 company is to be run, and they frame the business model of the said company. As per the business policy that's framed, it is apparent that the objective of the company is to collect deposits from gullible members of the public by presenting ambitious rosy pictures about projects and services of the company. So this is the first projection that is being that they take money for the purposes of collect deposits from gullible members of the public by presenting ambitious rosy pictures about the projects and services of the company.
Yes.
This is the first level of government. In the year 1996, salespersons of accused number 1 approached the family members and the complainant at their office 51 Nolini Safe Road, Kolkata 707, and represented that the accused number 1 was setting up resorts in various parts of India. The salesperson of the accused number 1 further assured that the resort of Corbett would be ready and operational by 1997. And anybody who's interested in the project can be a member and can agree to pay for a room in the resort on time sharing basis for enjoyment and use and utilization of that property upon the understanding that he would be allotted a single room apartment consisting of 1 bedroom, 1 living room, dining area, and 1 kitchen for a week every year at Corbett Resort starting from the year 1997. Sales representatives of accused number 1 also represented that at the relevant time, the accused number 1 was running resort at various places like Uti, Kodaikanal, Munnar, so and so, and is offering the occupation of various huts, flats, suites, and resorts to the public on time sharing basis for different time periods against the payment of different quantum of charges per fee, payable in lump sum and once and for all. Against such allotment of time sharing, reference number 1 retains the liability to provide the agreed type of accommodation and other facilities services as per the written agreement arrived at the time of allotment of such time sharing occupation for the whole of the period of the scheme called lease.
Yes.
That being induced by such representation, the accused person and believing these to be true, honest, and genuine, the complainant agreed to
avail membership of their corporate resort, which according to the accused person were to be operational from 1997 and agreed to pay for a single room apartment consisting of one bedroom, one living room, dining area, one kitchen in the said resort on time sharing bill and paid a sum of rupees 59,000. Or the accused number one issued certificate of membership and a customer number being so and so to the complaint. As per terms of the said certificate, the complainant was entitled to use a single room apartment consisting of so and so, so and so, so and so at the corporate resort for 1 week, 7 nights every year. On the 27th week, annually from 1997 to 2095. Apart from one membership, memberships were taken in the name of the family member, namely so and so, so and so, so and so. Although the construction of the said resort was to be completed in 1997, but till December 1998, the complainant did not find any resort in the site. By letter dated so and so, the complainant inquired about the status of the report. So, at finding no reply by letter dated so and so, the complainant demanded refund of the amount along with interest. Both the copies of both letters are jointly annexed to and so. By the letter dated 29 September 2021, the accused agreed to refund the along with 80% interest, but in the form of food vouchers or adjustments towards amenity charges towards other memberships. Copy of the letter is shown. That by the letter dated so and so, the accused number one requested transferring of membership of corporate to an operational resort. That by letter dated so and so, the complainant replied that he is not interested in any other resort, so either will allow him to enjoy corporate resort or refund the amount along with interest and loss. Copy of the letter dated so and so. Thereafter, the complainant made contact with the accused person on diverse occasions, but on every occasion, the accused gave false hope refunding the money. Even after such assurance from the accused person, the complainant surprisingly noticed that in the last few years, the accused number one has been changed their office several times without any permission. The complainant failed to understand the reason of such frequent change of office, and the accused one also did not inform the complainant of such changes. And as such, it became extremely difficult for the complainant to correspond. Moreover, the accused number one shifted his Chennai and Mumbai offices several times in the past few years. The directors and the other officers of the accused number one verbally assured the complainant that they would be refunding the said amount. Subsequently, they changed their stand and alleged that they were the financial constraints, but they still promised to refund their entrusted money with interest. The complainant still could not recall the trust paid to so and so report on the reason for such refund with good faith. The complainant continued to communicate with the number one authorized representative, then honor about so and so, Kumar, senior manager, so and so, who came to the office and held a meeting. Also, to discuss along with refund of corporate along with the interest. Accused number two further assured that he would discuss the matter with the head office and try to resolve the matter also. On 30th July 2016, complaint wrote to a headed person to deliver and close on requesting the commitment tasks, which were given with the complaint honorable so and copy of the letter. Thereafter, the accused number 15 contacted the complainant. No matter kindly sees this date, what becomes relevant is first week of June 2006.
Yes.
So, from 1996, they kept us going round and round. Till 2016, they are talking about delay. But the fact is that they did not pay and they kept on assuring. They kept on assuring us that yes, we will pay with the interest. Do not worry. First offer, let me just continue.
Yes.
Thereafter, the accused number 15 contacted the complainant saying that he has been referred the matter to the head office and assured to resolve the same within email dated 16 November 2016. But these are correspondences which are on record. Right? The accused number 15 demanded a copy of the letter so and so the accused number 1 for the complaint. On the same day, the complaint representative made short force. The complainant had thereafter for several times requested the accused the entrusted amount paid by the complainant to them and not being used by the false and fraudulent representatives along with them. However, the accused persons have deliberately neglected to refund the complaint in fines. The finally honorable so and so the complainant advocate had upon them to return the entrusted amount of 59,000 so and so paid for corporate research. In total, now the total has changed because it is interest which is coming paid by the complaint to the accused. However, despite this such letter, no payments were found to be forthcoming, and thus it became clear to the complaint that the accused had no intention of refunding the amount. That is, implied by letter to the accused person stated that till now they have not been able to complete the construction of the allotted quarter due to some PIL pending in Supreme Court for the first time. This is the first time in 3rd May 2017 that we come to know of this. Copy of the letter dated 21st April 2017 and letter dated 20 Act. They are most palpable that the complaint had entrusted this amount of 59,000 so and so to the accused company for membership and enjoyment and usage from the property amount. The understanding that he would be allotted room for a week annually at corporate resort starting in India from the year 1997. Admittedly, the resort had not been constructed in 2001, and the accused number 1 had admitted to refund the said money along with interest at the rate of 12 as on 30th June 2018. However, as per subsequent conduct would show that the accused person had no plans of refunding the money, and they were merely procrastinating the amount embezzled at their head. The day the company the construction of the resort, the company that is the fund of the money by him was time sharing money is property. Therefore, the accused became the trustee of the company's money that became due on cancellation of the agreement. This money continues to be the property of the complainant held in trust by the accused person, still accounted for and repaid to the complainant. Therefore, when the accused person hand back this sum, which became due upon cancellation of the agreement for time sharing, they are guilty of the offences described under Section 405 and punishable under Section 406. Though the agreement was cancelled long back in 2003, it was only with a email dated 19 January 2017 that the accused person refused to account for the company's property and made it clear that they have unlawfully embezzled the said property, and therefore it can be treated as property of the complainant lying in the trust in the hands of the accused person since that day. The accused person has been enjoying the property of the company by causing his wrongful loss and by enjoying the corresponding wrongful gain. The said property being the money was likely to earn interest at the prevalent bank rate, which is normal manner. However, the accused person is honestly held onto such property of the complainant and continued to enjoy the earnings of said property and did not refund the complainant in spite of speculative demand. It was only in January 2017 that the accused person members of the property of the complainant. Therefore, there was no unnecessary the in lodging this complainant on 25th July 2018 sought to lodge a complaint to the officer in charge against the accused person, but the police authorities have neither taken any step nor have they lodged the FIR and conduct investigation. The government made therein complete the copy of the complaint dated so and so with that annexed is correct. That the offence of criminal breach of trust may be inquired into so and so in whose local jurisdiction the entrusted property is to be accounted for. The said entrusted property is to be accounted for at the date of the complaint which is situated within the territorial jurisdiction of both subsequent and the court. Also, the false and fraudulent representations provided by the accused person to the complaint at the latter's office. Thus, this court has ample jurisdiction to pass the judgment. That for discovering the full scope and purport of the offence being committed by the accused person and for recovering the misappropriated funds and arrest and documentation of the accused person is very much essential, along with the search and seizure. Police authorities are only competent court to carry out the case as such. The company trade that it is it's at this stage that it's to challenge. But a stand was taken that 154 was not complete. But we had in an affidavit in opposition in page 23.
Yes.
So, keeps the affidavit in opposition page 23 in hand and sees page 60 of this one. Each of the page 60, what your lordship was with me.
Affidavit.
14. Yes. So the affidavit is also there. Now, what are the, if we understand Priyanka Srivastava, the prerequisites were 154.1, 154.3, affidavit along with the complaint, then calling for a report. Just a matter, basically. Overall matter, if mandates are it's on two counts. If we understand Priyanka Srivastava also correct, Priyanka Srivastava's primary reason of Supreme Court to pass orders was so that a person who is filing a complaint must take responsibility of two things. One, of the averment that is being made, so that if that person is lying, he or she would be caught. And appropriate steps can be taken in terms of law to punish him. That's one. For that reason, the aspect of verification was brought up. That's part C. Part B was that the procedural issues with regards to 154.1 and 154 ought to have been complied. Why? Is because 154.1 talks about the FIR, petition of a complaint which is disclosing cognizable offence must be intimated to the police for the purpose of registration of an FIR.
Yes.
Right? So 154.1 becomes an automatic mandate before a 156.3. If we understand, clear consider. 154.3 was 154.3 is nothing but a qualification of 154.1. That in the event you see that the person is not working, NOC is not working, or an SHO is not working, then you intimate the superior officer. Now the superior officer in terms of section 36 has all the rights and all the trappings of duty to either act as an officer himself or to direct people Now 154(3), section 36 was not discussed, but I am just telling you that in terms of section 36, it is very clear that
Yes,
he
yes.
takes all the responsibility himself. He has all the right to take the responsibility himself. So 154(3) is nothing but an exercise of the jurisdiction of a superior officer to emphasize and to ensure that 154(1), in the event a cognizable offence is made up, he shall direct and he shall ensure that that is done. There is registration. So Supreme Court says 154(1), 154(3), and then if not, then you come to a court of law. You come to a court of law. Maharaj, there have been scores of judgments, Maharaj, where even when 156(3) has not been done, the High Court jurisdictions have been moved with the 154(1) and 154(3) saying that police is not active. It is not unknown, it is not unheard of. Because the most important thing is whether the police was intimated and whether the superior officer was intimated. These are the two things. Now over here, Maharaj, your lordship takes page 23. I will not repeat of the affidavit in opposition. I will not repeat whatever has been stated because in principle it's the same thing that has been stated. But what I believe that my learned senior had argued, coupled with my learned junior friend who's here, Mr. Mukherjee tried to harbor the date which is 6th of October 2018. That is the date of filing of this petition. So he tried to emphasize that possibly there has been non-compliance of. I will just conclude with you. So, whenever you
Yes, yes.
So, Mr. Mukherjee tried to emphasize the 6th October 2018. He tried to say on the day when my application has been filed, there is abject non-compliance of 154(3). Right? Takes that to be something which is not record by itself. Because my 154, my 156 does not disclose. But if we look at the mandate of law, when the order of investigation, let us say for a minute, 154(1) is done. I have erroneously moved 156. The magistrate calls for a record. The magistrate calls for a record. My magistrate calls for a report answer. In the report, the magistrate is desirous of knowing that have you registered a case? If the answer would have been yes, I have registered a case, what would be the fate of 156? It would become incursion. Right? Because 156 is for the purposes of, if we understand it correctly, at the initial stage, 156(3) is meant for the purpose of registration of the case.
Yes.
Right? If it is meant for the registration of the case, then 154(1) at the time when 156(3) is being moved by a complainant, if 151(4)(1) fructifies into an FIR and the process starts, and from 154(1) automatically 157 starts. Because 154(1) effectively means that the magistrate is supposed to be kept in the loop in terms of 157(1).
Yes, yes.
Right? So even that, if the police gives a report in that we have started 156, 50 its character. Right? So the effective issue of 156(3) becomes germane till the time an order under 156(3) is passed. Because I have a right to take out my petition also if I desire. Right? So conceptually, till the time an order of 156(3) is passed, if there is a lacuna which is procedural in nature, a formality which has been mandated by Supreme Court, if it is fulfilled, then possibly that lacuna will not go to the root of the matter. It cannot legally go to the root of it. Why? Now, taking the facts as it is, 6th is the day when the case is being filed. For a minute, let us not look at the contents of the FIR. Let us look at the dates over here. 6th is the day when the FIR, the 156(3) is being filed.
6th of October.
6th of October is the day when the 156(3) is being filed. Now, We have not challenged this order.
6th of October 2018, the order which is being passed, I will read it out to your lordship. It's at page 19.
Certificate of good results are marked. Page 90. Certificate
Page 90.
first page.
First page of the certificate.
6th October. The order that is-
So this is there.
This is their certificate of. Actually, the first item they have said, including on
Yes.
11th October. 11th
So
October.
this order your lordship has seen the order dated 6. That's order number 1. Have a look at order number 1. That's 6/10/2018. Your lordship has got it?
Yes, got it.
Well, give me a minute. Now, C is order dated 6/10/2018. Has your lordship got that?
1610.
Now, 6/10. That's order number 1. And can we take it out for your lordship? Lordship gives us your lordship, right? We'll take it out.
Yes,
Your lordship has got it?
6th of October.
Very good. My lord, I'm sorry, my lord. 2 documents your lordship needs to see parallel. Keep one hand over here. Keep one hand over here and kindly comes to page 12, paragraph number 80. Page 12, paragraph. Well, your lordship will not see the affidavit in opposition right now. Just sees his petition. Page 12, paragraph number 18.
Your petition of complaint.
No, page 12, my lord.
You have got a petition. Revision. Okay.
There are 2 things which your lordship has to see parallel.
Page 12, paragraph number 18.
Yes.
Yes.
Now, reads paragraph number 18. Right in between from the order dated 11th October 2018. So, your lordship is seeing the order dated 6/10/2018,
Yes.
right? Your lordship is seeing paragraph number 18 that talk about 11th of October, right? Now, goes to paragraph number 17, first line. The petitioner says that the order dated 11/10/2018. So, 6 is not in challenge.
Where is the order dated 11th of October?
But we'll come to 11th October later. First, satisfies your lordship self that in their pleadings, 6th is not in challenge. Please, my lord, kindly comes to page 13, paragraph number 20. This is where they impugn the whole thing. Now, over here also, it is 11th October 2018. 6 is not under challenge. 6 is not under challenge. Now, let us have a look at 6. What is happening on 6? A petition of complaint is filed. A petition of complaint under section 156(3) filed by the complainant Ajay Kumar so-and-so against accused number so-and-so, praying for sending the same to Posta PS for investigation under section 156(3).
Yes.
After treating the same as FIR, learned advocate appearing on behalf of the complainant moves the said petition. Her learned advocate reads the petition of complaint along with documents filed. Considered, it is found that the complainant has already informed the facts of the incident to Posta by writing as it appears from the Xerox copy of the application filed by the complainant. In view of the fact, I think that a report is required to be called for from the Posta PS to ascertain whether any case has already been started. So 154(3)
If 154.1 would have happened, 154.3 was not required. So if he is calling for a record, he is calling for a report, is he wrong? Yeah. He's just satisfying in terms of clear cut have started it.
Yes.
Right? So there's nothing wrong with it. That is the reason why they didn't challenge it. Right? They didn't challenge it. Now this is nothing but a verification which is being done by the magistrate. Now in the meantime, I have shot a letter to the DC, Deputy Commissioner. Right? I've told the Deputy Commissioner, look, they are not doing. So if this document, page 23, which is there, it is being received on 9th, and a report is being given by the police on 11th. On 11th, when the magistrate is initiating investigation, how can it be called to be faulty when the system has been put to place? Your Lordship understands what I'm
Yes,
trying to
yes,
say.
I understand. I understand.
That if the case would have stood registered, let us say the Deputy Commissioner, first of all, two things, Madam. One is by order dated 6/10/2018. Was there any direction passed? If the answer is no, was the police injuncted from acting? The answer is no. If none of the things have happened on 6/10 and only a report is called for, and I have intimated the DC, the Deputy Commissioner of Police, stating that please see that my FIR gets registered. Am I at fault? The answer is no. Because approaching the magistrate and doing a 154(3) there is no bar. Nowhere in law has it been stated that you can ultimately what is it that I'm wanting? I'm wanting an investigation. Either I go here or I go there. Initially, these things weren't there till the time Priyanka Srivastava.
Yes.
Right. So Priyanka Srivastava put the cat amongst the pigeons. And that is why some element of confusion came. Now, in this situation, if I have approached both the officers together, I have gone to the magistrate, I have also gone to Deputy Commissioner's office.
DC.
I've gone to the DC's office. Am I at fault? The answer is no, because as a litigant, I'm knocking on every door possible for redress.
Now I understand. The argument is that
Yes.
According to the Priyanka Srivastava,
Yes.
the complaint, that is the application under section 156(3),
Yes.
has to contain the fact of 154(1) and 154(3).
Right. Now has to contain.
And your complaint is not within that scope.
Right. But this
is the argument by the Mr.
absolutely, absolutely. If this would not have gone, I would have been unlucky. I would have been wanting. But an averment of this level, which actually is being complied with legally, will that take away the case where no order of 156(3) has been passed, despite a 154(3) being not there? What is the test? That you must go to these two places. Ultimately,
Yes,
what is
yes.
the test? The pivotal substance is that you must go to these two places and then come. If your lordship, your lordship has also been a part of the lower judiciary, your lordship imagines your lordship sitting at the CJ. For a minute, a 156(3) is moved. Your lordship turns around and says, Mr. Banerjee, you are 154(3) done. Oh, yes, my lord, I have not heard it, my lord, your lordship. I'm listening to other. Well done, very good. The issue is whether Priyanka Srivastava's compliance in pivotal substance.
No, one issue is there also.
Yes.
If 154(3), 154(1) is recorded,
Yes.
and it was not informed to the complainant, so where is the purpose of 154(3)? Have you got it?
Absolutely, my lord.
When 154(1) is there, 154(3) has no leg.
Absolutely. It is only because the rule in terms of 154(1) is that a free copy has to be given to me.
Yes.
The essence of free copy is that for an accused, you have to go and take a certified copy. And the accused gets a certified copy only once 157(1) is complied.
Yes.
So there are some legal issues. Why 157(1) is happening is because the magistrate is put in charge of the total case so that there is no excess on the part. So legislation's concept is that if you have to seize something, it has to be intimated. 102(3).
Yes.
For a minute, let us revisit the scheme of the CRPC. If you have to seize something, you have to intimate the magistrate. You don't have to take permission. 102(3) does not talk about a permission. 102(3) talks about an intimation. If you arrest someone, then you arrest, but you would have to produce him within 24 hours because it is impinging upon his liberty. And if the magistrate feels that yes, there is validity in your arrest, then he shall allow you to keep him. Right? So at every stage, the magistrate becomes a cynosure of legal steps taken at the behest of the investigating agency.
Yes.
If that is the case, that is the reason why first in time, well, tens of cases we move in appeals where we show the difference of an antedated FIR by 157 documents. And we show that by way of the court records, which are LCRs, which are placed, where initial endorsement is there on the top of the first order sheet. Your Lordship can understand what I'm saying.
Yes.
So 157 is linked to 154(1). 154(1), the issue is that you must be given a free copy so that the person comes to know immediately. So whereas an accused is concerned, he has to get a certified copy. Right? So whereas 150, as correctly put, Maharaj, the law is that if I get a free copy, there is no need of going for a 154(3).
Yes.
But when you've not got a response from the officer in charge, automatically it becomes a case that I would have to go to a superior officer.
Yes.
Now, because of some dichotomy over here, Priyanka Sevastava is 2017, 2018, I believe. This is happening in 2018. Not everybody is a champion of law.
Yes.
So there has to be a little bit of leeway which can be given. And most importantly, this leeway will be of what? Of form, not of content. It is of form only, that form in the form of my complaint. I'm not talking about the case. I'm talking about the form of the complaint. Where is the name of the complainant there? The answer is yes. Name of the accused is there? The answer is yes. The body of the complaint talks about the gist of allegations? The answer is yes. Does it talk about the territorial jurisdiction? The answer is yes. Now comes to Priyanka Srivastava. Have you spoken about 154(1)? The answer is yes. Have you spoken about 154(3)? The answer is no. Have you sworn an affidavit? The answer is yes. At the time of passing of the order, is the 154(3) on record? The answer is yes. Now tell me, Mala, with deepest respect, does this call for a caution on this point? With deepest respect, my answer will be no. Yes. Because then we will be looking at a situation where just because there is an averment which is lacking, where the reality says that that document is before the court, yes, the system has been performed, then there is no question. It would be issue of a form. Right? When the contents have been met with, the form should not determine. But I'll stop here for today. Your Lordship would comment. Yes. I'll stop here for today. This is so far as Priyanka Srivastava and 154(3) is concerned. They argue that 154(3) is not there. I produced a document to show 154(3) is there. 154(3) is there. Well, it's pleasure would be to kindly keep this in the first week of December. Next week, I'm slightly tentative, if your Lordship so permits. Or I can do it subject to my learned friends over here. I can do it on Tuesday, if your Lordship permits me to do it on Tuesday. This Tuesday? Huh?
Holiday.
Holiday, Canada? Wednesday?
No, Wednesday would not.
Now, first one, then my Lord, I'll beseech your Lordship not to keep it. Monday will be too tight. Monday, my Lord, I don't think I'll
1st December, Friday.
Friday, 2 o'clock?
2 o'clock.
2 o'clock. Friday, 2 o'clock.
Very.
Friday, 2 o'clock. My Lord, in the event, I have a difficulty. If I come to know of a difficulty, I will circulate a letter and inform to my learned friend. Now, I will. He's related to me. So, my Lord, I will intimate my learned friend and I will also inform your Lordship one day prior.
Yes.
Deeply obliged, my Lord. Deeply obliged.
Okay, please write down.
But this is part of it.
Yes, the matter hardened part. That's the matter we fixed on 1st of December 2023 at 2 p.m. as a special fixed matter. Both the matters.
Deep your life, man.
Yes.
Aside better, I can make you on.
So it's a review application.
Yes.
You are on behalf of the
I am the
petition.
review. I am the review applicant.
Review
Order
applicant.
order passed Justice Naik. He has released the matter. Thereafter, by assignment, he will receive him.
Why it has been released? Anything matter?
Personal ground.
Okay, personal ground. So you are the complainant. You are the
I
claimant.
am the claimant.
Claimant.
And
And who is for the insurance company?
Mr. Pahari. Horrible
is there.
Pahari. In this matter, I am just giving the brief. I have the insurance company challenging the order of the award of the claim tribunal filed an appeal in 2010.
Very well.
I have filed the appeal in 2016 after 6 years. At that point of time, there was a determination of division bench. The matter was taken up by the division bench. There was a delay of about 6 years that was condoned. My appeal was registered in the year 2017. Then thereafter, appeal and cross appeal come into in this point. The insurance company filed the appeal that is 2804 of 2010, and my appeal is 197 of 2017. Matter was finally decided, Justice Patnaik, and delivered the judgment. There was some mistake. I filed the review application. In the meantime, there was a direction to the registry, Registrar General, to pay the calculated amount within a period of 6 weeks.
Okay.
The registry informed me there is a deficit court fees. You pay the deficit court fees, otherwise the draft will not be handed over. Draft is ready by and handover can be handed over, but it cannot be handed over because there is a deficit court fee. And as per the stand of the registry, I have filed an application on the basis of that letter that there is no deficit court fees. As per statute, I have paid the appropriate court fees in the court below when I have filed the claim petition.
Very well.
And that point, your lordship's particular order is required. Otherwise, they will not hand over with the draft. That was very essential because the draft is prepared on 6th September. Or I think that 2 months time is for the lapsing of the draft, and 6th December will be the lapse. If your lordship, at first that direction be given considering the provision of the statute, and then thereafter I want to press the review application. There was a delay in the review application about 67 days. What happened due to the delay was caused by.
What is the ground of review?
Yes, but there are 5 or 6 grounds. Mathematical calculation was a mistake. The multiplier was a mistake. Multiplier will be 16, but that has been taken as a 15. First point.
Multiplier we adopted 15.
But it should be 16 because age is 35 years.
According to the Sarala Verma, it was adopted to be 15.
But that is that I am showing 35 years 8 months.
What is the age?
Age, you not kindly.
Okay, 36 to 40 years. Sarala Verma says.
Yes, 36 to 40 is the 15.
15.
But below 36 would be 16.
31 to 35 is 16.
16.
Yes.
So I am entitled for getting 16.
Why 30? Why?
35. My age is 35.
No, in the judgment it was stated that your age is 36 years.
No. That is the mistake. That is the mistake.
That is
Yes.
the correct.
That is required to be corrected. That is required to be corrected.
Okay.
And another point is this: the rate of interest. The Supreme Court categorically stated the rate of interest should be 9%. There is series of judgment, 3 members bench judgment, but it has been come down to 6% without giving any importance of this 3 members bench judgment, without following any decision. I have mentioned 4 or 5 grounds, but I am just pointing out.
So you were here for the review on the ground of the multiplier and for the interest.
I am giving the grounds of my appeal. 5 or 6 ground is there. I am just reading out for your convenience.
No, it would be better if the Mr. Pahadi is there. So when can
I have already informed, but after assignment I have not.
because I came to know.
You just inform. Tomorrow, if it's possible, if there is no bar from your local bar.
But I do not know most of the advocates whether they come or not.
So you inform Mr. Pahadi, come on Monday. I will dispose of the matter. Review application, and if there is some ground of your review, I can pass down. No issue. And what about the
I have
deficit court fees?
deficit court fees. I
Have you filed any can?
Yes, I have filed an application regarding the. I do not know what is the number, 1 or 2. There is a 2 application before your lordship. One for clarification of the letter dated 4th September 2023, Registered General Administration, and another is for condonation of delay. And
Okay. Can 2 is for the clarification. And
all right.
Can 1 is the condonation of delay.
Can 1 is the condonation of delay.
So registry stated there are shortage of ad valorem court fees.
Yes, that point, Lord, I came to know from the registry also. During the division bench period, there was, if the High Court enhanced the compensation, never directed to deposit the enhanced deficit court fees, because the law is very clear. Kindly consider this. Section 331 is the relevant provision for under the Motor Vehicles Act for depositing the court fees.
Yes.
That means in my case, I have claimed for 14 lakhs. The 14 lakhs will come under category 4, exceeding 1 lakhs, 1% of the amount claimed. I have paid. There is no deficit court fees. There is a recording also in the trial court. But the view is this, Justice Pattonai, whatever amount enhanced by the High Court, you have to pay again. That is the subject matter of consideration, because the statute says the court fees has to be paid at the time of filing the petition before the claim tribunal. There is no provision. In case of enhancement by the High Court or Supreme Court, I am again required to pay the enhanced amount. No, never happened. Never happened in last 50 years. Never happened. This is the first time I got it. Because there is no provision at all. Even my appeal, whatever I have filed the appeal, there is no deficit court fees. Appeal is registered. If there was any deficit court fees, my appeal has to be defective. That is not the case. When the appeal is admitted, there is no deficit court fees, merely enhancement of the compensation. If there is no specific provision in the statute, I am not required to pay the deficit court fees on the enhanced amount, because there is no provision in the statute itself. The relevant portion is the judgment is regarding that payment is concerned. I am just pointing out. Paragraph 25. Kindly come to paragraph 25. Learned Register General High Court Calcutta, upon depositing of the aforesaid balance amount and interest as indicated above, shall release the entire compensation amount along with interest in favor of the respondent claimants in equal shares. There are 2 claimants. Upon satisfaction of their identity and payment of ad valorem court fees on the compensation assessed, if not already paid. That is the misinterpretation. Because as per the provision of the statute, on rupees 10, upon making payment of rupees 10, claim petition can be filed before the tribunal. Tribunal at the time of delivering judgment can give the direction, you pay such amount of court fees, then thereafter I will deliver the judgment. That is the provision itself. Upon payment of rupees 10, a complaint petition can be filed before the tribunal. The specific provision is there. I think whether their lordships was indicated that part or not, the compensation assessed if not already paid. I do not know what actually meaning. For that I filed this application, clarification. The registry letter, kindly see the registry's letter, that is page can 2. I have enclosed the letter.
Very well, I understand. You come on Monday. Inform him. Okay, please take down. The instant review application has been assigned by the Chief Justice. Stop. Learned advocate for the review applicant appears and submits that there are some merits to entertain the instant review application. Stop. Considering the having heard the submission of the learned advocate for the applicant, he is directed to inform the learned advocate for the insurance company, informing the fact that the matter shall appear in the list on 20th November, Monday.
20. Well, at 2 p.m. or
no, at the
top of the list. Top of the list. Okay.
You inform.
I will inform accordingly. The matter will come up at 10:30.
Time 89, I am certainly responded my I have received a notice of the court. I would like ready now. The requirement
Item number 89. ঠিক আছে ছেড়ে দিন। What about the administrative notice? You are for the respondent.
Respondent.
Who is for the appellant? Administrative notice were issued upon the appellant. No. By the number such and such, such and such, such and such. Neither the post office nor the particular had You are appearing for the respondent number. What is the number? What is the name of the respondent? YK Pradhan. YK Pradhan. Young Kim Singh Pradhan. Yes, you are the respondent number 1D. That is the sole respondent who deceased, who has been who is died, who has died since deceased. 1, 2, 3, 6 respondents are represented, substituted, and you are the D, respondent number D. So this is D. YK Pradhan. Okay. Hmm. Okay, please take down. Learned advocate, নামটা নেই. Your name? Kananda Kanjilal appeared on behalf of respondent number 1D, namely YK Pradhan. Stop. None appears on behalf of the appellants. On behalf of any of the appellants. On behalf of any of the appellants. Stop. Report of the department reveals that some of the registered consignment regarding the service of administrative notice upon the appellant was received by the appellant and some was received by the appellant, and some of the items, some of the registered consignment was not properly delivered. Considering the same, the office is directed to submit further report regarding the service of administrative notice upon the appellants as well as the respondents, as well as the remaining respondents. On or before 1st of December 2023. Let the matter be adjourned today. Place the matter on 1st of December 2023 at 2 p.m. Come on 1st of December. Let me see where are the appellants. If they are not appearing, I shall appoint one person to represent the matter. I shall dispose of the same.
My lord, may I mention, my lord, one matter, my lord, item number 86, your lordship. But the matter was also taken up prior to vacation, your lordship, and fixed also the matter today. But
you are appearing?
I am appearing on behalf of the appellant.
Appellants. But where is the file? Some say 6 time. তা বললে তো হবে না, আমাকে ফাইল লাগবে। Okay, come on next Friday. Next Friday, it will be appear in the list. I am taking the instruction from the department. Where is the file? File is not appearing.
I also couldn't file by Bhogavatnama due to the non-availability of the record, your lordship.
Let me find out.
I will explain the matter on the next day.
Yes, come on Friday. শুধু 86টারই ফাইলটা নেই। হ্যাঁ, ফাইল ইজ देयर, আমি দেখেছি সব ফাইল। প্রত্যেকটা ফাইল হাতে নিয়ে নিবি, তাই হয় নাকি? ঠিক আছে।